Lesson: Legal considerations for background checks and pre-employment screening. Understanding the legal considerations for background checks and pre-employment screening is crucial for HR leaders aiming to ensure compliance and protect their organizations from legal risks. Background checks and pre-employment screenings are integral components of the hiring process, used to verify the qualifications of candidates, assess their suitability for the role, and mitigate potential risks. However, mishandling these processes can lead to significant legal implications, including claims of discrimination, invasion of privacy, and violations of Fair Credit Reporting laws. The Fair Credit Reporting Act in the United States is a critical law governing background checks. It mandates that employers obtain written consent from candidates before conducting a background check and provide them with a copy of the report if any adverse action is taken based on its contents. A practical tool for HR professionals is a standardized consent form that complies with FCRA requirements. This form should clearly outline the nature of the background check, the information to be collected, and the candidate's rights. Ensuring this form is part of the initial hiring packet can streamline compliance and prevent legal challenges. Another essential framework is the Equal Employment Opportunity Commission's guidance on the use of criminal records in hiring decisions. The EEOC advises employers to consider the nature of the crime, the time elapsed, and its relevance to the job before making employment decisions based on criminal history. To facilitate this, HR professionals can develop a decision matrix that weighs these factors, providing a structured approach to evaluating criminal records. For instance, a candidate with a minor offense from a decade ago might be more favorably considered than one with a recent conviction relevant to the job in question. This approach not only aligns with the EEOC guidelines, but also promotes fair hiring practices. Internationally, the legal landscape can differ significantly. In the European Union, the General Data Protection Regulation applies to background checks, emphasizing data protection and privacy. Employers must have a legal basis for processing personal data, such as the candidate's consent or a legitimate interest, and ensure that only necessary information is collected and stored securely. HR leaders can implement a data protection impact assessment as a practical tool to evaluate the risks associated with data processing and ensure compliance with GDPR. This assessment involves identifying potential impacts on privacy, assessing the necessity and proportionality of data processing, and implementing measures to mitigate identified risks. A case study illustrating the importance of adherence to legal standards is the lawsuit against a prominent retail chain, which faced a class action lawsuit for failing to provide proper disclosure forms before conducting background checks. The court ruled that the company's forms included extraneous information, violating FCRA requirements. This case underscores the necessity for HR professionals to ensure that disclosure forms are clear, concise, and strictly contain information required by law. Pre-employment screening also involves verifying educational qualifications and previous employment. Misrepresentations in these areas can be common, as evidenced by a study indicating that 85% of employers have caught candidates lying on their resumes. To combat this, HR professionals can utilize third-party verification services, which specialize in contacting educational institutions and previous employers to confirm the accuracy of a candidate's claims. Implementing a checklist for verification can ensure consistency and thoroughness in the process, reducing the likelihood of overlooking critical discrepancies. Discrimination claims can arise if background checks disproportionately affect certain groups. The EEOC provides guidance to avoid disparate impact, advising employers to ensure that their screening processes are job-related and consistent with business necessity. One actionable insight is to conduct regular audits of hiring practices to identify any patterns that may indicate discrimination. By comparing the demographics of candidates selected for further screening with those who are not, HR leaders can uncover potential biases and adjust their processes accordingly. The use of social media in pre-employment screening adds another layer of complexity. While reviewing a candidate's social media presence can provide valuable insights, It also raises privacy concerns and the potential for discrimination based on protected characteristics, such as race, religion, or gender. A best practice is to have a designated team member, not involved in the hiring decision, conduct the social media review, filtering out any information that could bias the decision-making process. This separation of roles helps ensure that hiring decisions are based solely on relevant professional qualifications. Statistics indicate that nearly 70% of employers use social media to screen candidates, highlighting the prevalence of this practice. However, legal guidance on this practice varies globally, necessitating a nuanced approach. In countries with strict privacy laws, such as Germany, accessing a candidate's social media without consent could result in legal repercussions. Therefore, HR leaders should familiarize themselves with local regulations and develop a policy that outlines acceptable practices for social media screening. Moreover, the role of artificial intelligence in pre-employment screening is increasing, offering both opportunities and challenges. AI can streamline the screening process by quickly analyzing large volumes of data, but it also raises concerns about algorithmic bias. HR leaders should ensure that AI tools are transparent, explainable, and regularly audited for bias. Partnering with technology vendors that prioritize ethical AI practices can help mitigate these risks. Furthermore, HR professionals should stay informed about emerging regulations governing AI in hiring, such as the Algorithmic Accountability Act in the U.S., to ensure compliance and ethical use of technology. In conclusion, navigating the legal considerations for background checks and pre-employment screening requires a comprehensive understanding of relevant laws and regulations, both domestically and internationally. By implementing practical tools such as standardized consent forms, decision matrices, and data protection impact assessments, HR leaders can enhance their compliance and mitigate legal risks. Regular audits and policy reviews can further ensure that screening processes are fair, transparent, and aligned with organizational values. As the landscape of employment law continues to evolve, staying informed and adaptable will be key to maintaining effective and legally compliant hiring practices.